Welcome. Today we're exploring how property transfer through a will works for Muslim individuals in India. While Muslims can make a will, the rules are quite different from those for Hindus or Christians. These differences stem from the fact that Muslims are governed by their own personal law, the Muslim Personal Law Shariat Act 1937, while most others follow the Indian Succession Act 1925. In this video, we'll break down the key distinctions, explain the 1-3 rule, and guide you through the process of making, registering, and enforcing a will as a Muslim in India. Let's get started by understanding the basic legal framework. Muslims in India are governed by the Muslim Personal Law Shariat Act 1937 for inheritance and wills. This is different from the Indian Succession Act 1925, which applies to most other communities. While the process of writing and registering a will is similar for everyone, the rules about what you can do with your property, who can inherit, and how much you can give away are unique under Muslim law. Understanding which law applies is the first step in planning your estate. One of the most important differences in Muslim wills is the 1-3 rule. Under Muslim law, a person can only give away up to 1/3 of their total property through a will. The remaining 2/3 must be distributed according to Islamic inheritance rules, unless all legal heirs consent after death. For example, if someone owns property worth Rupee 90 lakhs, only 30 lakhs can be willed freely. The rest is automatically divided among the legal heirs. This rule ensures fairness and protects the rights of all heirs. A Muslim will tries to give more than 1/3 of the property, or if it favors one legal heir over others, it's only valid if the other heirs give their consent after the person's death. This means you can't simply write a will leaving everything to one child unless the rest of the family agrees after you're gone. Without this consent, the will is only valid for the 1-3 portion. This safeguard prevents unfair disinheritance and ensures everyone's rights are protected. Muslim law does not allow you to completely disinherit a legal heir through a will. You cannot write a will that gives all your property to one child and nothing to others. Such a will is only valid up to the 1-3 portion unless all heirs consent after your death. This rule is designed to maintain family harmony and ensure that everyone receives their rightful share. If you want to favor one heir, you must follow the proper legal process and obtain consent. There are some differences between Sunni and Shia rules regarding wills. Under Sunni law, a will cannot benefit an heir without the consent of other heirs, and the 1-3 limit always applies. Under Shia law, a will can benefit an heir, but the 1-3 restriction still stands unless other heirs consent. It's important to know which school of law you follow, as this can affect how your will is interpreted and enforced. Despite the differences in inheritance rules, the basic procedure for making a will is the same for Muslims and non-Muslims in India. You must write the will, sign it, and have it witnessed by 2 people. Registration at the sub-registrar's office is optional but highly recommended. Probate is only required in certain states or situations, such as in Mumbai, Kolkata, or Chennai. These procedural steps help ensure your will is legally valid and enforceable. Preparing a will, you'll need property documents, ID proof, details of your heirs, and 2 witnesses. After death, the transfer process requires the death certificate, a copy of the will, a legal heir certificate, and a no objection certificate (NOC) from heirs if the will exceeds the 1-3 limit. Probate may be needed in some cases, and you'll also need to apply for mutation in the property office to update ownership records. Keeping these documents ready ensures a smooth transfer process. Muslims have a unique advantage. They can gift 100% of their property during their lifetime through a process called hiba. Unlike a will, there's no 1-3 restriction on gifts. To make a valid gift, you need a declaration acceptance by the receiver and delivery of possession. This method is much more flexible and avoids the limitations of a will. If you want to ensure a specific person receives your property, gifting is often the safest and simplest route. Let's quickly compare Muslim wills with those of other Indians. Muslim law limits wills to 1-3 of property, requires heirs' consent for more, and does not allow full disinheritance. Other Indians have no such limit and can disinherit heirs if they wish. Both require 2 witnesses and registration is optional. Probate is sometimes needed for both. Understanding these differences helps you choose the right method for your needs. Register a will. Start by drafting it on plain or stamp paper. Include your name, age, address, property details, shares for each person, and a statement that it's your final will. Clearly mention that the will is made under Muslim personal law to avoid confusion. Sign the will in front of 2 witnesses who must also sign with their details. Registration at the sub-registrar's office is optional but gives your will strong legal backing and makes it harder to challenge. Extra legal strength. Attach a doctor's certificate stating you are of sound mind when making the will. This can be very helpful if the will is ever challenged in court. Probate is required in some cities, or if there's a dispute, the court will enforce the will up to the 1-3 limit and the rest will be distributed as per Muslim law. These steps help ensure your wishes are respected and your will stands up in court. Make your will as strong as possible. Follow the format in Section 63 of the Indian Succession Act, even though it doesn't apply to Muslims for inheritance. Register the will under the Registration Act 1908 and appoint an executor to handle probate and execution. If your will exceeds the 1-3 limit, heirs' written consent after death is essential. Attach supporting documents like doctor's certificates, Aadhaar copies, and photos of the signing. These steps give your will maximum legal validity. If you want your entire property to go to one son, a will alone won't work under Muslim law. The 1-3 rule applies and heirs' consent is needed for more. However, you can achieve this through a registered gift deed hiba during your lifetime or by creating a trust. Both methods bypass the 1-3 restriction and ensure your chosen heir receives the full property. Let's look at these options in detail. Safest and most straightforward way for a Muslim to give 100% of property to a son is through a registered gift deed known as hiba. This requires a declaration by the father, acceptance by the son, and delivery of possession. The gift deed is made on stamped paper and registered at the sub-registrar's office. Once completed, the property immediately belongs to the son, and no one can challenge it later. This method avoids all Sharia restrictions and future dispute. If you prefer to keep the property until your death, you can write a will giving 100% to your son. However, after your death, all other legal heirs must sign a no objection certificate (NOC) for the will to be valid for the entire property. Without this consent, only 1/3 will go to your son. This method is more complicated and depends on family agreement, but it's a legal way to transfer full ownership if everyone agrees. Muslims can also use trusts to transfer property. A trust is governed by the Indian Trusts Act, 1882, not Muslim personal law. You can create a revocable living trust to keep control during your lifetime or an irrevocable trust to give immediate rights to your son. Trusts are not subject to the 1-3 rule and are very hard to challenge in court. This method is popular among families who want smooth, dispute-free transfer. Set up a revocable trust, draft a trust deed on stamped paper, register it at the subregistrar's office, and transfer the property into the trust. The father remains the trustee and keeps full control during his lifetime. After his death, the property automatically passes to the son as the beneficiary. This method avoids the 1-3 restriction, requires no heirs' consent, and ensures a smooth transfer without probate or disputes. Setting up a trust involves several costs: stamp paper for the trust deed, registration fees at the subregistrar's office, professional legal fees for drafting, and stamp duty for transferring property into the trust. In Maharashtra, total costs typically range from Rupee 15,000 to 30,000, depending on property value and legal complexity. It's a small price for peace of mind and legal certainty, especially for valuable asset. If you're a Muslim beneficiary claiming property under a will in Vijayawada, Andhra Pradesh, you'll need to follow a specific process. Obtain the original will and death certificate, confirm the will's validity, and apply for probate if required. After establishing your rights, execute a conveyance or transfer deed, pay the applicable stamp duty and registration fee, and update the property records. Stamp duty is typically 5% of market value, with registration fees around 1%. Sum up: Muslims in India can make wills, but must follow special rules, especially the 1-3 limit and the need for heirs' consent for more. For full control over property transfer, consider gifting or setting up a trust. Always consult a legal expert to draft documents correctly and avoid future disputes. Keeping all paperwork in order and following the right process ensures your wishes are respected and your loved ones are protected.